All right, so this is LAWS 12066 land law, and today we're doing topic 9, easements. And easements are interesting. They are rights with respect to land, but they're not about the ownership of land, but they're about, what a right that you have that is linked somehow to the land, and that you can and can do certain things. And your materials, the books, casebook and the textbook and my notes have indicated different types of easements. Most common types of easements include, and I think we lost Tisha. Oh dear. The rights of way are very common as an easement. We've already seen. You might, if you cast your mind back to all the way back to the beginning of our discussion of the Torrens system, you might remember the Bursell and Berger Brothers case. And Bursell and Berger Brothers High Court decision, where the issue was not about the nature of an easement or how we understand that, but it certainly involved an easement. And we looked at that case then from the perspective of the indefeasibility and what was part of the indefeasible title that the registered proprietor, in that case in Sydney, in New South Wales, it was a parcel of land in Sydney, in the city actually, in the city area, had, because basically there was this structure above buildings, and the easement related to that, in relation to what you could do concerning that, build and so on and so forth. But you couldn't work out the detail of it until you actually went and read terms of the easement, which of course were not sitting there. All of the content was not sitting there on the in New South Wales we call certificate of title, but it had a number, a registered number, obviously, and you then go and you could look at the actual instrument of easement itself, and then you could read about it and what it entailed. And the question was, you might remember when we looked at that case, was in the context of Torrens and indefeasibility, did you have to go and look at that to work out the full nature of what this embraced, or not? Could you just rely on what's actually on the certificate of title? So there was a bit of backwards and forwards on that. And Windia in the end said, well, really, it's conventional and prudent conveyancing practice to go and look at the instrument to work out what it relates to. And then there was debate about that. There's been some controversy going forward about that. So we saw easements actually quite early on, but we didn't focus too much on them, on the structure of them and so on. But, they're not uncommon, but they relate to this, these rights, and very typically they are with regard to, a link, in a sense, to adjoining parcels of land. So, you will have seen there is this idea of the servient land, dominant land, the land which is benefited, the land which is burdened. Notice I'm using the phrase land. I'm not using that more, what's the word I'm looking for? More prosaic word. Tenement, right? And whilst it's technically correct to use the word tenement, I do think that we need to find every opportunity to use plain language in property law, in modern language. In my view, it's far too much of this hanging on to and harking back to this arcane language. It's there, it's in the law, it's in the case law, but it really, we can use more plain ways of expressing things. And I think that behoves us. Certainly, if we started talking to our clients, for example, about tenements, and they wouldn't have any idea what we're talking about, right? And interestingly, and I'm affirmed in this, that and I follow this lead, ARPL use that nomenclature as well. So they refer to the dominant land, they refer to the servient land, they don't refer to that other more technical word, tenement. Okay, but you know, I'm if you want to use that word, I'm happy. But you can use it. But I'm just saying, always look for the language which is more inclusive in terms of plain language, more direct language that people can all understand what's happening, not just within our circle of property lawyers and property law students and whatever, but just in a general way. Just a little bit, there's no questions on this, but just a little bit at the end on profits prendre, rights really with respect to mineral exploration and that sort of thing, mostly. One thing just, and this doesn't really, there's not much discussion about this in any of your materials, but I did just highlight it for you in the notes on page 4, that there has been an amendment to the Land Title Act. There's been many amendments, of course, several, but Division 4AA. Division 4AA in terms of high density development easements, sections 93, 96 capital E. And we might just pop across to Land Title Office, Land Title Act. And if you just open that up to 93 to 96E, sections 93. And, you know, you can see there types of easements which are referred to under Division 4AA. So, for example, section 94, high density development easement is an easement created for one or more of the following purposes: support, shelter, projections, maintenance, roof, water drainage. A high density development easement may be created only over 2 small adjoining lots or a wall of a building situated on one lot, etc., and so on. And also you can see there physical dimensions of what a small lot means and amounts to. So, you can get some clarification, of course, on that a little bit if, for instance, we just come back to the website for the course, and if we just go to the page on the message of the week, and I've got for you there, as you know, the Queensland Land Titles Practice Manual, Queensland Land Titles Practice Manual. Always useful to be aware of that. That's, of course, legislated under the LTA, as you know, and you will find a whole lot of interesting material there. And surprise, surprise, you can go in and there's a specific section, Part 39, on high density development easements. The other areas covered by the Act, of course, are dealt with as well. But it just gives you some background, interesting background. And of course, not all of, I mean, Aisha's not taking conveyancing grant is. There's a reference there and a link through the practice manual to the BCCM Act. Just an indication of that. So always be aware of the Land Title Practice Manual. It can help to clarify your understanding. I know some of you have already referred to that in quiz, for example.
Michael, I think it's quite helpful that...
Oh, sorry, I can't hear you, Aisha. Yep.
Oh, sorry.
No.
I think it's quite helpful, that practice manual. It's far easier to read clearly than the legislation. It's got things in there that aren't necessarily in the legislation as well.
Absolutely. Absolutely. And, I think it behoves us to inform ourselves from a variety of sources to provide clarity, okay? And we have, firstly, we have the legislation. We must always go firstly, as we know, in anything. Of course, if there is legislation, we must go to the legislation first. Then we go to the body of case law. And, of course, we're confronted in this area, and both of you have picked up a bit in this terms of the second problem question, which we'll get to presently, picked up on, and that partly, that was the reason I put the question there, was to throw up the differences in Queensland yet again, so that we find that through the innovations of the provisions of the legislation in Queensland, the situation is different in Queensland to in other places in Australia, other jurisdictions. So yet again, and Aisha and I, we've had a bit of a chat about this, yet again we're confronted with this issue of, well then, okay, if we know that, or we come to understand it, how do we then, what do we do with this vast body of case law, sometimes fairly complex? How do we then apply it or use it, or does it have any continuing relevance? And the answer or the response to that is, well, it does, but it has to be contextualised into the particular environment and the legislative conditions of Queensland. Grant.
I was going to say, it's useful for persuasive arguments, for trying to support, if you want to deviate from sort of the strict black letter literal interpretation of the Act, then potentially it could be quite persuasive.
Indeed, but where the circumstances are different under the different legislative conditions in Queensland, that needs to be noted. I mean, we've seen that before, for example, in the area of exceptions to indefeasibility with regard to the personal equity exception or the rights in personam exception. So we have this body of case law that's been working away, trying to work out what that means and how it continues to be an important exception to indefeasibility. But in truth, how all of that case law is about a principle that is known to the courts, which the courts have preserved as an exception to the indefeasibility which the Torrens Act provides. Or what do you do in the situation in Queensland where that's actually been captured within the Torrens Act itself? All that case law, which is not actually about that situation, how do you apply? So we don't know the answer to that universally, of course, in every situation, but we do have to work with that context. That's what we have to work with. That's our sandpit, if you like, in Queensland. Plenty of sand in Queensland, but that's our sandpit in Queensland. So good point, Grant. Yes, that's right. Aisha, any thought on that, or?
No,
that's right.
nothing.
That's fine. But also, your point, Aisha, about the usefulness or the utility of the Land Practice Manual, I entirely agree. So we've got the legislation, we've got the body of case law, we've got the more dense, if I can put it like that to you, the more dense explanations within, the texts, the case book, the textbook, not unintelligible, by the way, but, dense, so no, don't resolve from that. But why not? Why not have full access to something like this Land Title Practice Manual, which has been developed by titles registry staff to basically assist understanding the framework, right? And it is legislated under the LTA, and it is not something that exists in all jurisdictions. And it's written in plain language, and it's written in a fairly straightforward way. Not only does it do that, but if you got the land, have you got it open, by the way?
No.
Can you open it? The Land Title Practice Manual. It's hyperlinked from the website under the weekly message.
No, I've got it open.
Yep. Just open it up, Aisha, if you can. I've just gone into part 39, High Density Development Easement. Just wanted to point out something to you.
sorry, I'm just opening it now.
Yeah.
You can
Part 39. So this is not all of what the LTA deals with regard to easements, right? This is just that specific section under Part 4AA or Division 4AA, an amendment with regard to high density easements. But what I want to just point out to you was that as you walk your way through it, yes, nice, clear, easy to read, usually, generally speaking. Do remember that it's written from the perspective of the Land Titles Registry. Always remember, the perspective from which the document is or a guide, whatever is written. So just be mindful of that. But very useful nonetheless. I'm not suggesting it isn't. But the other thing that is quite helpful is that it actually gives you, if you go to page 39.6, page 39.6, it actually gives you an example. It actually gives you an instrument of a high density development easement. And it shows you the form in which it's required to be completed. And you can see there that in that particular one, we have the purpose. You can see on the form, it actually states the various purposes that are permitted under the Act, and all of them have been crossed out, bar the first one, which is support. And then, of course, it gives you, guide to how to complete. Very interesting on page 7. How much case law do we have on this? Nil. But not only do we have nil case law, this is on these high development easements, right? High density development easements. So not only do we have nil case law on this, notice the currency of this document at the bottom of each page. This has been updated. Well, I've taken this from the website because I hyperlink the website. So if you do that, you're getting the most recent version all the time. You can download the whole thing if you want to, but just accessing it on a needs basis from the online link means that you're getting the updated version all the time, I think, which is most useful. You can see that that's updated at the 1st of July 2014. So it's right up to date, well, virtually so, right? And that's excellent, as both for practitioners, but also for our purposes, in my view. And it's also showing us practical examples of how the principles and the rules and the ideas that we are thinking about and reflecting upon and discussing work in reality. What is required for the registration of an easement, and what form and how does it look, and so on and so forth. How are the matters spelled out? And there you go. So that's going to be quite useful. And so I encourage you to use that and refer to that as appropriate for the remainder of the course, insofar as that's useful. And what else did I want to say? That's all, I think, really, in terms of by way of opening remarks. Yeah. All right. So let's go into problem 16. I think both of you had a bit of a go at this. Who wants to start off?
I think Grant does.
Volunteered by his counsel.
Thank you very much. All right. Now I'm just going to go back into it. There was a one-line question, I think. What is the objection to easements in gross? Now, I started from, funnily enough, I've actually found it quite difficult in most of the text to really get a very clear definition of an easement in gross. I found going to one of the cases, I didn't read the whole case, but I certainly went to one of the cases and got a sort of a partial definition from that, and certainly enough to understand, I think, what it is, which is a burden to a servient, well, we'll say servient land now, using the layman's terminology, as you're saying, that where there is a burden, but there is no dominant, there's no dominant land, there's no benefited land. So that could be, some examples of that could be drains, power lines, water pipes, the water board, etc. So where the access is for an authority or for somebody that doesn't have a corresponding sort of benefit or against that one.
So it's a bit of
on that basis,
a one-sided thing, isn't it?
Yeah. So on that basis, that because there isn't the corresponding parcel of land, it's difficult to class it as an interest in an estate or directly as an interest in the land itself. And that seems to be where it's a fallacy, and it falls over in terms of trying to register that interest unless it's supported by a statutory authority, and that's where the legislature comes into it. And obviously they can legislate on whatever they want. But that seems to be the underlying context of the objection, is that it's simply not a valid estate, a valid interest in land that is transferable in that sense, or assignable.
Aisha, have you got any thoughts on this?
Yeah, I pretty much agree with what Grant said. That it appears at common law and just generally, an easement requires both the dominant and the servient land, but an easement in gross can be created without a dominant land. Therefore, as Grant said, it's more one-sided, and it's legislated in the LTA in Queensland.
Can I just stop you there? And this is for both of you. Why does an easement require this benefit and burden on adjoining land? What's the rationale there?
I'm a bit stuck on that, to be quite frank with you. I kind of understand it, but I find it very hard to verbalise why there needs to be a burdened land and a benefited land.
Well, my response is a lot more simple. It's simply because the text and the case law says so.
Oh dear. Oh dear. Oh dear. Oh dear. Well, let's take an example. All right, let's take a right of way. Okay.
So can I just say one qualifying remark? Because from what I read, I don't see why there needs to be a dominant piece of land, because if you're just giving a right of way and right of access, to me that right is an interest in itself, but that just seems logical to me. It seems like common sense, but then based on what I've read, it's just telling me that that's not the case, and that's where I've not been able to establish that link.
Well, let's take a common type of subject matter of an easement, and that is a right of way. All right. What purpose does a right of way serve?
What purpose? It would be access, wouldn't it? Ease of access.
Mm-hmm. And how does that access, do you think, links to this idea of benefiting and burdening?
Well, it benefits one because they have the access of the right of way, and then it burdens the other because they have to allow that right of way or that access.
You have to give a practical example, Aisha, because that's the best way to understand it.
Okay. Yeah. Okay. So let's say a battle axe block or a block that is landlocked. So you have the only way to get to the property at the back from the road is via one way, which is a shared driveway.
That's right.
Would that be correct?
That's good.
So what that means is that the dominant land, let's say, is the one that receives the benefit, and that is the access, that is the right of way. And that would mean that the property or the land at the front is the servient land, because they are burdened by it, by allowing or having to allow that access via that shared driveway to go up and down past their property or through their property.
And what's the rationale for the law recognising that?
I have no idea.
I don't think that's true. But we'll come back. Grant?
Isn't it to say that land doesn't become useless? I can't remember the exact terminology, but it was something along those lines.
Useless, I suppose, yes. That's
Sorry, Grant and Michael.
Sorry,
I've just got a plumber just ringing at the doorbell. I'll be right back.
You can join the conversation, actually. So useless. Can we
unusable? I can't remember the case concerned, but it had a very clear definition that basically said that the.
Can we turn that around rather than looking at it from like useless as opposed to use and enjoyment? How about looking at it from that perspective?
We'll say that there is an ability to use that land.
I mean, using Aisha's battle axe property scenario, which is quite a good one, and we can also think of other ones, for example, in commercial situations where there may be a right of access or a carriageway, possibly between buildings, that allows access to the rear of the building, and there might be the need for that access by others who don't have interests in the other buildings, or indeed in the certainly don't have any interest or proprietary interest in the actual land upon which this carriageway is constructed or built, but without which they cannot actually get at that which they use and occupy. Just imagine if the law didn't have a mechanism for requiring the servient landowner to accept an easement of this nature. What would be the consequence? I know you've mentioned the uselessness of the land, but what would be the bigger consequence?
That it would deny that other party from the enjoyment of that land, because they simply wouldn't be able to gain access to that land.
Exactly. It would also, more significantly, deny them the capacity to exercise their proprietary rights. And so this really is getting at some deeper idea, in my view, of trying to strike just balance here, so that property owners and property occupiers can exercise rights of enjoyment with respect to land, because the land has to be able to be used. I mean, we've seen arguments already about tying up land so that it can't be used. You know, even when we go back to the topic on the rule against perpetuities or remoteness against vesting, that was, you know, the rule against perpetuities, which was developed and is now enshrined within legislation, is to counter precisely that, to counter this idea of locking things up, locking up land so it cannot be used. What's to be achieved? There's nothing. It's counterproductive in many ways, not just legally, because the law is actually a sort of a structure here to support economic and social objectives and purposes. Grant?
Then how, and I do understand that, but then how is that different to if there's a residential development that potentially blocks access to a beach? And I know that it's through a statutory initiative that it happens, but then there's a public sort of right of way, a public access granted through that residential land or through a rural property to give public access to a beach or to a river or some other sort of amenity, then there is no sort of dominant land unless you're calling the beach dominant land. So that's where I'm sort of, I do understand. It's just, to me, it's just the difference between you've got two private parcels of land versus
that's right.
public land or public access.
That is the difference.
Isn't that public?
Oh, you're back, Aisha. Is the plumber joined? I hope
Yeah, sorry.
Well, it's not entirely irrelevant what we're talking about, right? We're going to get to drainage easements, the most exciting aspect of easements, shortly.
Okay. Okay, great. Exciting.
Drainage and sewage easements, they're the most exciting, I can tell you, right? So the point here is that easements, like freehold covenants, which we'll come to next time, right, are essentially mechanisms between private landowners, mostly, putting to one side this idea of easement and gross for a moment, mechanisms that have been recognised between private landowners to allow the land to be utilised and enjoyed, and to strike a balance between the rights of landowners, where a failure to recognise such rights would actually deprive an owner of the rights of enjoyment and access and occupation. But where you don't have two private landowners and you actually have public authority or the state, the political state, the Crown, whatever nomenclature you want to talk about. Let's hope we're not in, we won't get into the Scottish referendum just at the moment, but anyway. That changes the equation. It changes the equation because the state or the government or that public area is something that everybody has access to. And the government who owns that land or has responsibilities over that land, better way to put it, has responsibilities to the entire community. So, and the nature of how it's held and how those responsibilities are understood are different to those that a private landowner has. The government of the day doesn't assign and transfer its interest from one government to the next, like happens with private land. It can obviously assign or sell the land, but in terms of passing from government to government, in terms of public ownership, that doesn't happen. And the interests that are protected and served is not just the government, but it's the entire community and the society. One of the challenges that we have in Australia is that we moved in the direction of what I might call, for want of a better phrase, not a very eloquent phrase, but parcelisation of land, where everything could be parcelised apart from that which continued to be crown land. There wasn't, and crown land could be dealt with by the Crown or the government of the day in various ways, but that crown land was not about preserving a sense of the commons for everyone to enjoy and habit and use, as exists in some other places, including in England, for example. Just to give you a practical illustration of that, in Australia, when you move outside of metropolitan areas and you move into regional and rural areas, you just constantly encounter fences and barriers and signs that say, do not trespass, do not cross, this is privately owned land. You do not find dedicated public access ways and public commons outside in rural and regional Australia. But, for example, in England, you do. So you can very easily traverse private land through areas which have been reserved for public access through private land. historically. And these things are even mapped out on and chart, you know, put down on maps and so on and so forth. So very different history there in terms of the evolution of land and its use and so on, but that partly stands behind. Grant?
Yeah, I just wanted to sort of offer a bit of contrast, and I may have a misunderstanding here because, okay, I'm in regional New South Wales. There are property developments and subdivisions taking place all over the place. There are farms being broken up, and as part of the planning approval, the councils are only granting those approvals subject to the owners dedicating some of that land for public space, some of that land for easements passing through the subdivision, so that where there was no public access before, now the council has taken the opportunity to basically create access for the public to go through that development to get to another, you know, part of the, you know, whether it's a park or something else. But from what I can see, and this is where I may be wrong, and this is why I'm a bit unsure, I thought that essentially these property developers were being obliged to create these easements as private landowners. They weren't actually transferring that right to the council or to the public. They were just imposing in that subdivision these easements. And that to me, that would be an easement in gross, wouldn't it?
It's in the nature
or
of... Or
is that not?
It's better to refer to it as a statutory easement, basically. And basically it's a... I mean, when we say that, you know that the Parliament can do basically within constitutional power whatever it likes. And if it proclaims within power that the sky is orange today, the sky is orange today, subject to judicial review. And this is the circuit breaker, right? So it's not actually operating as an easement as the common law understood what an easement was, because the common law is basically trying to get an accommodation between private landowners. But it's taken up the phrase because it has characteristics similar to an easement, but it's subject to statute, and it's defined according to what is permitted under the statute. Right? And just like, for example, technically we should not talk about a right in personam in the Queensland context. What we should talk about is a Section 185 exception, a personal equity exception pursuant to Section 185, because that's what's been recognised in Queensland. And only then do we go back to as we know, to the body of law to help us understand and explain what that is. And that's similar here. So we only go back to the body of law that's evolved with regard to the nature of an easement and its characteristics and so on, insofar as it's helpful to understand this slightly different creature, that is a statutory easement, which operates differently. Now, the interesting point, and thanks for bringing it out.
Michael,
Sorry?
I was going to say, is it still... Oh, sorry.
Sorry, Grant.
Do you want to go, Aisha?
I was just going to say, I thought that the exceptions to under the LTA obviously would come under, say, fraud and if you had notice and, you know, all of that sort of thing. However, how does that apply to an easement? I'm a bit lost on that, sorry.
Well, the easement, of course, this really takes us into the second problem question, I think, Wealden Burrows. So there's a reference to easements in Section 185, subsection 1 and subsection 3. All right. So when I was talking about when I gave you the example of the exceptions to indefeasibility, it was I was just using that as an illustration of where the legislature has intervened. It's a different scenario, and you have to follow the language of the legislative provision, and then the case law becomes relevant as appropriate. And just because they call it something that looks similar to what the common law previously understood or recognised doesn't mean it's the same. That's the point you've got to recognize, come to terms with. So, for example, we talk about a statutory easement, but we have to go to the legislative provision to work out what that actually means in the first instance. We can't just rely on the general law understanding of what an easement is to work out what a statutory easement is, because it might actually be a bit different, but it may draw on features of what an easement actually amounts to. That's true. Now, getting back to your point, Grant, about what is being done with regard to the creation of such things in rural Australia or regional Australia under legislation. Well, that's right, but that's a response to the fact that they didn't exist before. And what I was saying, the point I was trying to make was that in other places, in England, for example, these things existed within the general law, so that you had recognition of these rights of access, not through the intervention of Parliament, but as an understanding that there was a general commons that was everybody's. And that's a different view about property, actually. It's sort of, and that's can only be explained historically. Basically, historically, in the sense that in Australia, when we've got to go back into our discussion in foundations to reflect on this aspect, but with the way in which the idea of land ownership emerged in Australia through the doctrine of tenure and so on, all property was subject to, land was subject to Crown Grant. And over time, we've had to find, how do we deal with the tension between that historical reality and the development of native title and so on and so forth. But because of this idea of the Crown Grant, meaning that initially all the land mass was in the control of the Crown, and then it could be, grants could be given to various people to do things and so on and so forth. Whereas in the UK or in England, that wasn't the case. So, that takes us beyond what we need to be thinking about at the moment, but it sort of does provide a bit of a background picture to what we're talking about here, because what we're talking about here is, rights. We're talking about rights, and we're talking about how we recognise these rights so that people that own land and have rights with respect to those lands can exercise them appropriately. The point here is what I wanted to get to through going back to Aisha's example of the battle axe property. What is the servient landowner getting from acceding to the creation of the easement?
Not a lot.
He's getting title to the property because it's conditional for him to take that property that he concedes that access.
So it's a negotiated thing, okay? It's a negotiated thing, and people have to, again, the law is, through its various ways and means, just, encouraging or cajoling people to be reasonable in the way that they come to an accommodation on things to allow this enjoyment of land to take place. And, adjoining property owners need to work together, and if the servient landowner was intransigent on this issue, well, the owner of the landlocked battle axe property could find some other way to be just as intransigent on some other issue and create problems and issues going forward, right? So that's sort of an accommodation process, really. And the other point is that there's this relationship in a genuine easement scenario between the burdened land and the benefited land, okay? And that then has consequences, so that the burdened land, the owner of that land, can't do things inconsistent with the easement. So it limits what that person can do. So they can't actually build structures you know, that block the easement, block the right of way over which there is the easement, because that's, you know, defeats the whole purpose of the exercise. But what has the law done to ensure that this will carry forward and continue to apply in relation to the adjoining lots?
They've allowed enforcement rights, I guess, haven't they?
Well, we've said that this is about an accommodation between the landowners, but does the easement actually bear on the landowner or on? What am I getting?
No, it's on the land.
Precisely. So it becomes, I think Grant mentioned this before, it becomes an estate in the land, so it attaches to the land, doesn't it? Thumbs up?
Thumbs up.
Thumbs up.
Thumbs up.
Oh, good. 3 thumbs, right, good. So it attaches to the land, it creates an estate in the land, so therefore it runs with the land when the land or the interest in the land is assigned. So the law has found a clever mechanism to enable it to continue to apply to the land irrespective of who owns the land. It's not a personal obligation, but it's a proprietary interest on the land. And if we're looking at a Torrens parcel or a Torrens lot, as we must in Queensland, then where do we find the easement?
As an encumbrance on the title.
Exactly. And we find it on the indefeasible title, and we find it listed as an encumbrance. And you've even used the correct nomenclature there, Grant. In some places, it's called. It is an encumbrance, but listed in the schedule and whatever. But in Queensland, it's actually encumbrances, and they're listed down there like that. The problem, of course, and this actually takes us into Wealden and Burrows, and I know Aisha's desperately wanting to talk about Wealden and Burrows. That raises the point that not everything is necessarily created expressly, and is able then to, you know, be get the benefit of being registered, but it might be implied, or it might be indirectly, or, you know, suggested as a necessary you know, adjunct to something else. And that's a bit what Wealden and Burrows is actually about. And so what do we do in that scenario? And this is really taking us in, we've moved across between the two problem questions, but that's really taken us into that second one in relation to, you know, what is the effect of that ruling in Queensland, and you know, what do we have to do with that?
Well, that's where it runs directly into conflict with the Torrens system as applied in Queensland in terms of having indefeasible title. If there is no interest registered, then a person takes that interest free of interests that are not visible or registered or that don't show on the register.
But, of course, we do know that in Queensland we can still have unregistered interests. But Section 185 is pretty explicit, isn't it?
Well, it all but rules out that if it didn't exist at the time of the original initial registration, then, say for some very exceptional circumstances which don't appear to have been before the courts in Queensland yet, it would seem that it just rules it out completely.
That's right. Why don't we just, I don't know, did you do this in your answer, Grant? Did you go to the Land Title Practice Manual?
I just went straight to the LTA.
Let's see what the Land Title Practice Manual has to say on this matter, if anything.
Yeah, they do have something about easements in gross on there.
I think we're looking at 185 at the moment, Section 185.
No, I meant with the practice manual.
Yeah, I did too. Yep.
Okay.
All right, we might come back to the. You take us, Aisha, back to the idea of what's said in the manual about easement and gross. We can start with that, and then we can proceed to this.
Oh, okay. Well, I'd love to, but I can't remember. I'll be there.
There we go. There we go. Well, we've got part 9 dealing with easements. Might be there. I have to admit I don't have an encyclopedic memory of the land title practice manual.
I'm pretty sure it's under 9.
9-2180. Okay, 9-2180. If we can find that paragraph. Easements in gross. Here we go. An easement in gross is only registered against the burdened land and is granted to public utility providers under Section 81A of the Land Title Act or Schedule 6 of the Land Act. We won't deal with that because we don't worry too much about that. And various providers, utility providers are listed there. Types of easements. Public utility easements may only be created in favour of a public utility provided for rights of way. There's the famous drainage and sewerage easement. I don't know why it's famous, but anyway, it's the supply of water, electricity, etc. Water storage, infrastructure corridor, public thoroughfare. Yep. So there's a good description about that for you. Just make a note, just while we're on this point about the easements for statutory authorities, don't ignore the fact that the legislation makes provision for these, some more innovative forms of rights. So, for example, they're on at 9-2185, an easement created pursuant to Section 437 capital A of the Petroleum and Gas Production and Safety Act 2004. Right, and we've seen that a bit before in terms of some of the exceptions, going back again a bit earlier in the course, exceptions to indefeasibility, some of those more innovative exceptions that are now incorporated within the LTA. And again, very, very usefully, we have an actual practical example of an easement of this kind that's provided for us. Yeah, so that you can have a look at that. I was actually looking, what was I looking for? Oh, that's right, Section 185. Where will we find that? Introduction. It's just, it's an example, again, where we've had a development and an approach in Queensland which is not reflected, I can't really find them, anyway, doesn't it? Everywhere. So that Section 185 is fairly explicit. And if you want, I think you've already, both of you have had a look at this, but in ARPL, the discussion there dealing with this, the matter of Wealden and Burrows and the exception and the way in which that should be understood in Queensland, pages 849 to 850 of ARPL, and the point with respect to Section 185 specifically on page 850. But that's not the universal position in all jurisdictions, right? And it's interesting, one of the things which is interesting about this course for you folk is that of course, we are benchmarking ourselves against the Queensland legal framework, which we must do, because you're ultimately, in the first instance, will be seeking admission before the Queensland Supreme Court. But many of the people in this course, your colleagues, are not necessarily sitting in Queensland. Certainly one of you is not sitting in Queensland, and there's many not in Queensland. So just to have an appreciation of the difference in the other jurisdictions, in their, what we might call home jurisdictions of some of the people in the course, is useful. And to also be aware that the way that this has been dealt with in Queensland is not universally true. So, for instance, on page 850 of ARPL, the text writers say that the application of the doctrine, this doctrine in Wealden Boroughs, to Torrens land in New South Wales, Victoria, South Australia and Western Australia is supported by judicial authority, in some cases law referred to. And then they go on, of course, to say that in Queensland, of course, it seems to be quite clear that this does not apply to Torrens land in accordance with Section 185. So it's an example, again, of difference. And, so you have to be aware of that difference. That's the thing. You've got to be aware of subtleties, and you have to be conscious that, for example, in something like Wealden and Boroughs, where it got to such a degree of status that it's even been referred to as the rule in Wealden Boroughs, in Queensland is displaced by legislative provision in accordance with the LTA. There's a good explanation of what the nature of what was going on in Wealden Boroughs there, on pages 849 to 850, and just a statement there of Theja's elements in terms of that, in terms of how do you understand, a quasi-easement and so on and so forth. But ultimately, in Queensland, it actually doesn't apply. And that was actually a bit of a trick question, I suppose, in a way, to get you to unearth that and to think a little bit about the nature of the type of easement that was being discussed in Wealden Boroughs, but then ultimately to see, in Queensland, there's been a change because of the specific inclusion of these, the way it's been included within that provision of the LTA. The thing that one needs to be aware of is that one can always to look into the deeper purpose and aims and objectives of what's going on in these various areas that we're investigating in the course. And it's not just, at the end of the day, a case of understanding in a very technical sense the concepts and the law and the legal framework and how it works and how it doesn't work and how it fits together in various pieces of the puzzle. But in my view, it's very important to grasp the underlying purpose and the underlying reasons for why we have the framework that we have, and also for why there have been changes and adjustments in the way that that's evolved over time, and also why there has been legislative intervention. So, for instance, in this area, not only including what we've just been discussing with regard to Section 185, but we've already seen the beginning of the class that in Queensland, under the LTA, we now have a further amendment with regard to high-density development easements. Now, we don't have any case law on that, but we have the legislative provisions and we have the discussion in the Land Title Practice Manual. So we need to just have an awareness of that as well. Any burning issues that you want to toss up?
I'm happy.
Happy, that's good. That's very good. Aisha?
Plumbing issues for Aisha.
Plumbing issues, okay. All right, look, I'm conscious that people are still concerned and interested, obviously, in the moot assessment. and that's not due until tonight. But look, I think we'll wrap it up here in terms of easements. I've said what I wanted to say on the topic. Just the last, and I just reinforce the point that I've been making. Be aware of the current developments. Be aware of these reform issues in the area, and also be aware of how the framework of law that has evolved over time is contextualised within the Queensland situation under the Queensland legislative framework. That's what's important, and that we need to be mindful. It's not only the Land Title Act, the LTA, but also the PLA has a role to play in this area as well. When we look at covenants next week, freehold covenants, we'll see how they work as well, and they're about also essentially private agreements between adjoining landowners, and again we'll see how they work and see that is that the same or different to the way easements work, and again we're looking at the idea of rights and obligations between adjoining landowners in a sense. So just say by way of close, next week I'm going to be giving 2 classes on the Friday. So the regular class at 2 p.m. Will be on covenants, freehold covenants, which is topic 10. And then in the evening, I think at about 7, I think that's a convenient time for people, and I'll obviously send out an email about this. We'll deal with social housing, which is topic 11. And then at the end of the class, or the tutor on social housing, then I will make some remarks, observations, if you like, in relation to the final assessment. I hope, do my best to try and hopefully get the moot assessments graded by then as well, so that certainly you've got the benefit of that and marks on that. Certainly, absolutely, you have them before you sit the final assessment, but I'd like to have them done by that final class. I'll do my best, say, see how we go. Did a lot of marking recently, but that's what I'm trying to do for you. And so all right. If there's no further questions.
Thanks, Michael.
Oh, Aisha, you're back, right? Sorry,
I'm sorry. I was just discussing the incinerator.
Indeed, as you would. Look, the recording is there. If you missed bits of that, just quickly, just to recap. Next week there'll be 2 classes. We'll do covenants at the regular time of 2 p.m. We're going to do social housing, topic 11. I think maybe at about 7 p.m. And then I will make some remarks and observations about the final assessment at the end of the class on social housing. And hopefully you will have the moot assessments back by then too.
Okay. Thank you very much.
That's a pleasure. Okay. Now, and remember, keep enjoying land law.
Oh, absolutely. Yep. Got that book under my pillow.
Yeah, Land Title Practice Manual under your pillow. That's right.
Absolutely.
Okay.
That sounds like you have to get out more.
I know.
Bye for now.
See you.
Bye.
Bye.
Bye.